Good morning, sir.
Good morning.
Sir, you were charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 17th, 2025, an officer was dispatched to a call for service at the 400th block of West Gray Street, Houston, Harris County, Texas. Upon arrival, the officer observed the defendant sitting inside his vehicle. The officer made contact with the defendant and observed the defendant to have bloodshot eyes, unsteady balance, and was confused. The defendant stated he didn't have anything to drink. A Houston Fire Department employee, the wheel witness, stated the defendant was asleep in the driver's side of the vehicle with his foot on the brake and the vehicle in drive. The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN, 5 out of 8 clues observed on the walk-in turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were 0.179 and 0.175.
Where was he? Was he in the middle of the road?
It sounds like,
He...
yeah, I don't. So it says that he was sitting inside his vehicle on the 400th block of West Gray Street, which is accessible to the public. On a public road.
Don't, please. I have no idea what that is, where it is. Is he in the middle of the road? Is he in a parking lot? Is it Domino's Pizza? I mean,
It says it's on a public street. It says, well, more specifically, it says 400 block of West Gray Street. It's a public street.
I mean, I need more information. I mean, does it say he's on a street there, or are you assuming?
No, I'm not assuming. I'm saying what it says is that the 400th block of West Gray Street is a public street. It doesn't say specifically.
Doesn't ask him if he's driving, none of that in there? I mean, really?
Yeah, he did have the vehicle in drive with his foot on the brake and was unconscious. But
wow, this moment is crucial. The judge just refused to assume anything without clear evidence, which shows how probable cause really works in court. It's not about feelings or assumptions, it's about solid facts. Do you think the judge made the right call here by dismissing it?
But in regards to the location aspect of it, there's something further stated on that.
Yeah, I'm sorry. I'm going to find no probable cause. I can't just go forward with assumptions here, you know? Mr. Cleary, be safe, man. You know, we have every single day. Look, this weekend, how many people died on the road here in Harris County? You know, really, be smart.
Thank you.
You know, you have but one life. Don't do something where you either ruin your life or, more importantly, ruin someone else's life. Okay?
I appreciate
Please
that.
take a seat for me, sir. I'm going to find no probable cause.
All right, Judge, next is case 4, Door, Adam.
Mr. Dory, you're charged with assault with a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir.
Officer was dispatched to a disturbance. The complainant and the defendant are in a dating relationship. The complainant stated the defendant shoved her multiple times with his elbow and also grabbed her arm, causing pain. The officer observed the complainant to have a scratch on her chin, scratches on her arm, and a large purple bruise on her right arm.
Know that he hit her? Do we know?
So the complainant stated the defendant shoved her multiple times with his elbow and also grabbed her arm, causing pain.
All right, Mr. Doran, we're going to find that there's sufficient probable cause to go forward with your case. This case is 1,139 days old. If you take off again, I'm going to make the bond so high, you'll have hair falling out. Do you understand?
Yes, sir.
As it stands now, I'm going to put an ankle monitor on you so I know where you are at all times. You will have a GPS monitor. I am now also issuing a protective order that you're not to have any contact with this person whatsoever. Miss Ray Perez is now a protected individual. You cannot commit family violence or an assault against this person. Commit and act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, be in possession of a weapon, or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this protective order, the state can and will file a violation protective order. It's one of the worst cases you can pick up. Do you have a lawyer today?
No, sir.
What are you doing about that?
We need to find one.
Okay, we will give you time. I'm telling you now, I'm fast tracking this to trial. In 30 days, is discovery complete?
Discovery, it looks like we are missing some photos potentially, but besides that, discovery is.
If you can try to get on it. I'm 30 days, I'm putting this case to trial. Do you understand? It would behoove you to immediately go out there and start trying to find a lawyer. I'm gonna have you go to Victoria, sign a reset. After that, you'll get with Felicia for your bond conditions. I'm gonna have you take a seat while we create all the documents. We'll have you sign it, and then you'll be free to go, sir.
Yes, sir.
Mr. McIntosh, you're charged. You're on bond for a theft. You've now picked up a new theft. On the new case, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6, 2025, an officer was dispatched to a shoplifting call at Walmart in Harris County, Texas. The officer made contact with the asset protection staff. The complainant stated that he recognized the defendant from a previous encounter. The complainant observed the defendant grab multiple items and attempted to leave the store, passing all points of sale without attempting to pay. Defendant stated he owned a Purple Heart Veterans discount and therefore the amount
That
stolen.
was the first theft, right? I remember that from the first one. That's 254, right?
Right, so
Notice how calm the judge stays while dealing with repeat offenders, but there's clear frustration building underneath. When someone keeps getting arrested for theft while already on bond, it really tests the court's patience. What would you do if you were the judge? Give another chance or lock him up?
no, this is 255. So maybe similar facts.
Then that's the exact, then that must be the exact same as the first one.
Let me check. Right. Yeah, that's my thought. So the older theft is from December 16th, 2024.
Right.
And that was from Melrose, and this is from a Walmart, and this is on March 6, 2025. I'm not seeing anything on the previous theft regarding the Purple Heart discount.
Okay.
Would you like me to start over?
Just so, to Walmart and how much?
$283.62.
Judge, if you can recall, this is the young man that you had granted a pretrial, you had given a bond for him. You had me to talk to his mother to see if his mother would have a place for him to stay. And she said yes, provided that he puts up an effort to try to get a job and et cetera.
Oh, I remember that.
Yes,
Okay. But he now picked up a new case.
Now, he had.
Have we addressed that since the new?
Yeah, we addressed it. We knew that he had picked up another case. That's why you were upset that he had picked up another case while he was on bond for the previous theft. But the court was kind enough to still give him a bond because I had spoken with the mother, and the mother informed me that he could stay there and where until such time that he.
Are we doing another arraignment then
Right.
today?
Yeah, bond conditions have already been set for this.
And here's the big takeaway. The judge is giving him one last opportunity to turn his life around, but with strict conditions. This is the balance between justice and mercy in real time. One more mistake, and this man's freedom could disappear instantly. Think he'll actually change this time?
Vic, why are we doing a arraignment? Is today just a regular setting then? I'm showing them both set for,
Door. Okay, yes, Judge, I guess it was just a regular setting. He
Don't-
got a PR bond, and on the
Right.
bond, it had today's date of billing.
if you pick up a third case, I'm going to absolutely lose it. Do you understand?
Yes, Your
You
Honor.
must get a job or be in school full-time.
Yes, Your Honor.
Do not use any illegal drugs. If I find that you're using, I will lock you up. Do
Yes,
you
Your Honor.
understand? We've given you now 2 PR bonds on the first one one PR bond on the second case. That's 3 PR bonds. You will not get another one. Do you understand?
Yes, Your Honor.
In the next couple weeks, I'm going to send you for a drug test. If I find that you're using, it's not going to go well for you. Okay, so I guess let's set this case out for a couple weeks because I want to know what he's done to get a job. I'm setting your case out for 1 to 2 weeks. I want to see what you have done to get a job. If you have done nothing, if you come here and show me that you have not filled out at least 10 to 15 applications for a job somewhere, it's not going to go well for you. Do you understand?
Yes, Your Honor.
All right,
Thank you,
so
Judge.
1 to 2 weeks, you're going to get tested when you come back.
Yes, Your Honor.
Understand?
Yes, sir.
All right, Mr. Lee, thanks.
Thank you, Your Honor.
Thank you.
Have a